If your baby was hurt during a traumatic delivery, you're carrying enough already. So here's the honest, plain version. You may have a case if the medical records show warning signs during labor, a delayed response by the team, and a real injury afterward. But in Louisiana, you have to act fast. The deadline for these cases is generally just 1 year. It applies even to a baby. And reviewing the records is how you find out whether something went wrong. This is the part that costs families their case, so please hear it. Louisiana recently extended the deadline for ordinary injury claims, like car accidents, to 2 years. Medical malpractice was not changed. A birth injury claim is malpractice, and that still runs on a 1-year clock, generally 1 year from when it happened or was discovered, with a hard 3-year ceiling, and the law applies that to children too. So if someone told you that you now have 2 years, that's the car accident rule. It is not the rule for your baby. The questions doctors and lawyers ask are the same anywhere. Was there fetal distress on the monitor that wasn't acted on? Was a needed C-section delayed? Do the cord gases, the APGAR scores, seizures, brain imaging, or the NICU records line up with the baby being deprived of oxygen? None of that is something a parent is expected to judge. It's why the records, not your memory of a frightening day, are where the answer actually lives. So the first real step is gathering the right paperwork. That means the labor and delivery chart, the fetal monitor strips, the operating room and nursing notes, the APGAR scores and cord blood gases, the NICU and transport records, any brain imaging and pediatric neurology, and later the therapy and developmental evaluations. Together, those tell the story of what happened and whether the care fell below the standard. Louisiana also has some specific rules worth knowing. Most malpractice claims first go through a medical review panel before a lawsuit, and starting that process pauses the clock while it plays out. There's also a cap on certain malpractice damages, though future medical care for the child is treated separately. These are technical, but they're exactly why getting the records in front of someone who handles birth injuries early matters so much. So, you may have a case if the records show warning signs, a delayed response, and a real injury. Louisiana gives birth injury claims roughly 1 year, not the 2 years you may have heard. The medical records are what decide it, and the review panel and damages rules make moving early essential. Everything I mentioned is linked below, including the full written guide with sources. This is new lore for Dudley DeBosier injury lawyers.